As far as emerging and developing issues are concerned, obviously the ADA is going to be a big area of concern for the EEOC going forward. Frankly, the ADA is also a big area of concern for your state Fair Employment Practices agencies. And I know in Massachusetts we have our own referral agency, and I'm sure many of you out there in the audience also have state agencies, and you probably are finding that the ADA and your state anti-discrimination statutes are causes for concern. The 100% healed policy is a policy where you might have somebody who's out on a work-related injury and out because of a work-related injury. You might be granting that person a leave of absence, but you've told that person that you're not going to be able to come back to work until you're 100% better. And if you have that kind of a policy, take note, get rid of it. It's per se going to be considered illegal as far as the EEOC is concerned. You always have to consider, is there some sort of a reasonable accommodation that would allow that individual to return to work, even if they're not 100% healed. The same thing is true about the fixed leave of absence policy. You may be familiar with the Sears case, which goes back, I think, a couple of years now, but that's where Sears was hit with a substantial penalty for its, we call them in our practice, we call them a cliff policy, where you say the individual has a leave of absence up to a certain point and then they're done. If they don't come back, and in Sears' case it was after a year, if they didn't come back after a year and they had been out because of a work-related injury, Sears terminated them. Didn't consider whether or not there was any reasonable accommodation, didn't consider whether an additional week, 2 weeks, 3 weeks, month, whatever, would have allowed them to return to work. So be very, very careful. If you have a fixed medical leave of absence policy, you need to be careful to be sure that it allows some flexibility, that extensions are going to be granted on a case-by-case basis. You need to contact management. Things of that nature need to be in the policy. As I said, even where fixed leave of absence policies are extraordinarily generous, and that's the case with Sears. It was a year-long leave of absence that they were giving their individuals with work-related injuries. But if it was an absolute cutoff date, and if leave can never be granted after that date, that really violates the interactive process and could create big problems for you. So your best practices, review your leave of absence policies. We're telling our clients that they need to have a separate medical leave of absence policy, because your obligation to engage in interactive dialogue and perhaps provide a job-protected leave of absence, that arises before the individual is going to be eligible for FMLA and after the individual has exhausted their FMLA. The FMLA is not the only leave policy that is available to your employees now that the ADA has created some of these concerns. So be sure that your medical leave of absence policy does not have a definite end date, that your employees are eligible before FMLA eligibility and after FMLA expires. Now there are differences in the ADA. There are different things that you can require of those employees, but just be sure that your policies reflect the law. Question? Yes, please. Good question. So the question is, if you can't have a 100% healed policy, what can you have? Well, in any time that an individual is returning to work after some sort of an injury, you always have to go through the process of checking with their physician and showing them a copy of the job description. Here are the physical requirements of the position. Can the person do this job or not? And if the doctor releases them to do that job, then basically you're required to accept that person back. Now, if the individual comes back to work and you have objective evidence from which you can determine that that individual might still be suffering from some physical problems. Let's say he's been injured, he's injured his back. He comes back to work, and the first time you see him in the warehouse, he's crying out in pain every time he lifts a box. Well, at that point then, you are permitted, because it's a medical examination that would be job-related and consistent with business necessity, you are permitted to then send that individual for a fitness for duty examination, only because you have objective evidence. But if you get a release and his doctor says it's okay for him to come back to work, you really can't challenge that unless you have your own objective evidence. But suppose the doctor sends him back and he's not fully capable of performing all the functions of his job. Then the question is, what is he capable of doing? Are the things that he's not capable of doing essential functions? Are there modifications you could make to those essential functions that would allow him to do the job? It has to be an interactive process. If you'd like to discuss that further after I'm done, I'd be happy to chat with you about it.